Okay, so thank you for joining this webinar. It may just be me, but I find this a particularly interesting challenge that faces us and a very interesting development with regards to GDPR and how that impacts on non-EEA data transfers, which is one of the elements of GDPR. So just to introduce you, for those who don't know me, my name is Mark Gracey. I run a business called Mark Gracey GDPR, and I support businesses with their GDPR compliance, primarily through a support package, a monthly subscription, which gives you access to online tools and resources, a help desk, and so a limited email and phone support, and if you need it, access to some of my time to do some of the tricky stuff for you. I'll talk a bit more about that towards the end. I've been involved in data protection since the 1998 Data Protection Act came into play when I was working at an internet service provider at the time, and have been involved in regulatory compliance and other compliance areas ever since then. So what we're going to be covering today is basically the Schrems II case, and I'll explain what I mean by that if you're not familiar with who Max Schrems is, and the implications on Privacy Shield, the standard contract clauses, and specifically EU to US data transfers. So I'm going to cover some of the basics of GDPR and where that sits with regards to why we're talking about this, what the case actually means, and what the court case findings say, what this means in practice, and what this might look like going into the future. Now, I prepped the presentation yesterday, and since then the Information Commissioner has updated their guidance. So I've got a slide that covers what we'll be looking at, what they're saying at the moment, and yes, I've updated that accordingly. But it's as accurate as we know as of about 10 o'clock this morning. I don't think anything has changed since then. But I think it's going to be a moving feast, and certainly we're expecting to see more guidance from the ICO, so I'll talk about that towards the end. So GDPR and restricted transfers, what does that all mean? Well, so this slide represents a summary of GDPR. Data protection, of course, is all about the protection of personal data, so any data enables you to identify an individual, whether that's an employee, a supplier, somebody in a business, or a consumer, or a citizen, or us as our own individual people. And one of the elements of data protection is the data protection principles, which are basically the rules. Now, it's not officially a principle as defined in GDPR. It used to be a principle in old data protection terms, but there are rules about non-EEA or European Economic Area data processing, and that fits within these set of rules or these principles about what you can and can't do. The other areas on that slide I'm not going to go into. There is some relevance to it, but obviously there are other areas of GDPR which I'm not going to cover today, but the lawful basis, individual rights, and accountability are the key other areas. So what does the GDPR say about data transfers outside the EEA? So Chapter 5 is dedicated, or Chapter 5 of the GDPR is dedicated to this particular area of the rules. And basically what the law says is if you're going to process data outside the EEA, then you must ensure that there are appropriate safeguards in place. And there's a number of ways that appropriate safeguards can be found. Firstly, the EU can declare that a country's data protection law is adequate and meets the European standards. And that top bubble there with the arrow pointing with a long list of countries, there isn't that many countries there actually, but those are the countries that are deemed to have appropriate or adequate data protection. So if you want to process your data in Argentina, then you can do so. If there isn't an adequacy decision, then you need to look and see whether there's been any other decisions or agreements made. And very pertinent to this afternoon's discussion is, of course, the Privacy Shield, which is a special agreement between the EU and the US that says that if a US company signs up to the Privacy Shield, they're signing up to EU standards of data protection, and therefore, if they've signed up to Privacy Shield, you can process your data in the in the US using that organization. But there's a big but, which we'll cover, which is what this whole presentation is about the fact that Privacy Shield has now been declared as invalid. Failing that, there are legally binding contracts, of which there's two forms. If you're processing data and sharing it within a group of companies, then you can have what's called binding corporate rules, which allows for an internal transfer. And that means that you have to have basically a contract with the other parts of your business where that business is outside the EEA. Those contracts have to be, or those rules, I should say, the BCR, the binding corporate rules, have to be approved by the ICO. So you have to get them to sign off on them. So quite a lot of businesses that are in that situation actually make use of the other tool that's available, which is a non-negotiable contract set out in an EU regulation, which is referred to as a standard contract clauses, or you might see the acronym SCC, or sometimes referred to as model clauses. Google refers to them as the models. I think they call them the model standard contract or something like that. They are basically a piece of, a set of contract terms that you have to cut and paste from an EU regulation and put into an agreement between a controller who's in the EU and is processing their data in a non-EU country. And the concept there is you're binding if you're the controller, you're binding the processor to the legal requirements for adhering to EU law. And the contract clauses also give the data subjects a method of recourse should there be some kind of harm or suffer some kind of damage from a breach of that contract. There are also some exemptions, or exceptions as they're called, and Article 49 of GDPR sets those out. They tend to be, if you've got explicit consent from the data subject, so you're acting in a public interest or under a contract, and there's a few others, but I'm not going to talk about the exceptions. The focus of today is all about the appropriate safeguards in terms of Privacy Shield and the standard contract clauses. And I'll get on to why this is important in a moment, particularly if you're sat there thinking, but I'm a UK company operating in the UK, how can this apply to me? We'll come on to that. But first, let's talk about the Schrems II case. Now, it's called Schrems II because it was started by a guy called Maximum Schrems, who is a privacy activist. And it's number 2 because he's already taken, I think, remember if it was the Irish Data Protection Commissioner to court over other issues. In fact, this timeline arrow sort of starts back in 2013-15, where he successfully got Safe Harbor, which was the previous sort of the father to Privacy Shield. So Privacy Shield came about because Safe Harbor was invalidated in 2015, and this was because of a court case by Max Schrems, who argued that it wasn't appropriate when this data was being processed in the US. In 2015, having successfully put the kibosh on Safe Harbor, he started a new action claiming that the standard contract clauses, so these dictated contract terms that meet the appropriate safeguard requirements of GDPR, are also not appropriate because of his data being transferred. And he seems to focus a lot of his efforts on Facebook and where his data is being used in Facebook and processing by Facebook. So his argument is the data is that he puts on Facebook in the EU gets actually pushed to the US and processed in the US, and that doesn't provide, or Facebook's contract terms doesn't provide adequate protections for his data because of US national law. So the reason the Irish Data Protection Commissioner is involved is because the Facebook has a European representation. So they have their European headquarters is based in Dublin. So actually, since GDPR's come in, the Irish Data Protection Commission has found themselves rather busy because a lot of the big US tech companies have headquarters or bases in Europe, in Dublin. So they now fall under the remit of the Irish regulator, but essentially the Irish regulator is the Irish equivalent of our Information Commissioner's Office. So Max Schrems accuses the standard contract clauses of not being adequate enough. Whilst this is going through the court process and the European process and various other things, Privacy Shield comes in 2016 to replace Safe Harbour, and the Irish Data Protection Commission passes the case. Well, they have a discussion in Irish courts, and it ends up being referred to the European Courts of Justice, CJEU. Of course, 2018, GDPR came in on 25th of May, and last year there was a preliminary hearing of the case about Max Schrems and Facebook and the Irish Commissioner about the issue with the standard contract clauses, and it was a non-binding decision made by a legal judge who basically said that the standard contract clauses were okay, but there were maybe some questions with Privacy Shield. So everybody was kind of thinking, because normally these non-binding decisions tend to run into what is the final decision and what is the outcome from the court case when it actually happens. So people were expecting it to be, maybe some questions about Privacy Shield, but it was not going to be necessarily a strong challenge, but nobody really knew, and we've been waiting until the 16th of July, so a couple of weeks ago, where the court case was actually held in the CJEU, and this led to the following outcomes from that court case. Now, the most significant thing is that Privacy Shield has been invalidated, which means that Privacy Shield as a lawful basis for processing data outside the EEA is no longer legal. And it's also brought into some questions about the standard contract clauses and whether they're appropriate when you're dealing with a non-EEA country, particularly the US. Now, the reasons that Privacy Shield were defined as invalid was mainly around US surveillance programs and various pieces of legislation. So you've probably heard of PRISM, which was the thing that Edward Snowden announced was going on in the UK, in the US government, where they were intercepting communications and monitoring people's emails and all these kind of things. And there's an act called the Patriots Act, and there's a few others that give surveillance powers to the US government and for national security, essentially. So being able to get access to data on the internet so that they can track down serious crime and terrorism and things like that. So what the court found was that Privacy Shield provides no protections for EU citizens who may be sort of scooped up in any of these surveillance programs, and they have no recourse for doing that. So there is no controls in the US law around limiting what is necessary, so only collecting the data that you actually need for whatever investigation they're carrying out. And as I say, there's no data subject redress. So it was declared that because the national law in the US trumps what the Privacy Shield requires a signatory to the Privacy Shield to follow rule-wise, doesn't provide any protections for EU citizens, and therefore cannot be valid. So Privacy Shield is now being declared invalid, just like Safe Harbour was back in 2015, or possibly earlier. I can't remember if that's the right date. So if the US government have the power to force particularly large tech companies, and typically some of the laws only apply to people like Apple, Amazon, Microsoft, Google, etc., some of the big US tech companies, if that means that Privacy Shield isn't valid, then it also brings into question how valid these standard contract clauses are, given that they too could be overridden if the company or the receiver of the data, the processor of the data in the US is bound by that US law. So there is a suggestion, therefore, that we should be looking at our standard contract clause agreements with processors in the US and therefore anywhere else in the world outside the European Economic Area, to make sure that we think that the party that will be doing the processing is not going to be having to hand over our data should they be required to by their national law. It suggests that maybe the supervisory authorities, so for us it's the Information Commissioner's Office, it's the Irish Data Protection Commission, etc. There's various different regulators across Europe in the member states. They should take some active part in working with data controllers, so the organisations in Europe that are processing the data outside, to consider whether standard contract clauses are appropriate or not, and they should, if necessary, declare that certain standard contract clauses with certain organisations aren't appropriate. So this is a big deal because we need to consider what we're doing with our data processing, and the reason it's a big deal is that you have to look at that wide definition of processing that is in GDPR, and GDPR says that processing is anything you do with some personal data. So it's not just the processing you do for the purpose which you have it. It is if you're storing it, editing it, deleting it, manipulating it, sharing it, even deleting it is all considered processing. So if you're storing your data in a cloud service, and that cloud service is US based, so Microsoft, Google Drive, OneNet, Dropbox, etc. And they are relying on Privacy Shield as, if you're using those services, or if you're using other cloud-based services like a CRM, if you're using something like HubSpot, for example, if you're using MailChimp as an email marketing platform, they're all storing and processing your data in the US because their servers are based in the US. There may be some configurations that you can tweak to change where you have your data stored within their platform. But things like MailChimp, for example, you don't have that choice. You use their service. Your email addresses that you use for your email marketing are stored on their servers. And whilst you're using their service to send out your email marketing, because of this wider definition, because they're storing and enabling you to process your data, they're a data processor. So that means if any of these third-party processors that you have are based in the US and have servers only in the US, or don't put your data on any European servers, and they rely on Privacy Shield, you can no longer rely on Privacy Shield because it's just been deemed invalid. So when you think about your processing activities, you need to look much wider than, say, the marketing company that you might be using that's doing some processing for you to send out your marketing campaigns, or the virtual assistant who you might be sending some data to make some tweaks to it to convert it from one spreadsheet to another, or whatever you might be doing or inputting into a system. If you're using storage, CRMs, mail processing platforms like MailChimp, etc., there's a good chance they're not based in the EU, and therefore there's a good chance you're processing data outside the EEA, and there's a good chance they're in the US. So this is why it's a big deal, because Privacy Shield means if they're relying on Privacy Shield, they can't anymore, so you can't rely on them signing up to Privacy Shield being appropriate. If they're not relying on Privacy Shield, or what is very often the case is they say we sign up to Privacy Shield and we provide the standard contract clauses, then you will, in theory, have signed up a contract or signed to agree to a terms of service, which include the model clauses, the standard contract clauses. But of course, we've still got this issue of the fact that maybe the standard contract clauses are not appropriate as well if those organizations are subject to US law, which says hands over your data whenever we ask you to. So there's now a question then about what does that mean about the validity of any standard contract clauses and any processes you're using that are relying on Privacy Shield as their way of safeguarding the appropriateness of the data transfer, the data processing outside the EEA. As the ICO put it, or actually it might be the European Data Protection Board, they've referred to it as your data goes on holiday wherever you are processing it, essentially. So you need to think about where your data is in the world and decide whether it's relying on Privacy Shield as a protection, in which case you can't do that anymore. If they're relying on standard contract clauses, you've now got this balance check, which you didn't have before, to determine whether those contract clauses are in fact appropriate. Will the ICO publish a list of contract clauses that they're happy for you to transfer your data to Google because they decided that Google is okay? what that's going to look like, we don't really know. So in a minute, we're going to talk about what this, what we know so far. But so to just summarize up to this point, this court case is a big deal because it means we can't rely on Privacy Shield anymore, and brings into question the validity of standard contract clauses without appropriate checks and balances to ensure that the government of where that country is, where you're processing your data, doesn't have the ability to basically trump any EU law and just gather up EU citizens' personal data and process it regardless of what anybody would have signed up to with the standard contract clauses. And so what we're actually looking at is, what does this mean in practice, and what do we know so far? I could have easily just put one slide up and said, not very much, it's all a bit of a mess, because at the moment we're not too clear on what's going on. And as I said at the beginning, I first pulled this presentation together yesterday, and then even since then there's been an update, and we will need to continue to pay attention to what the ICO are telling us and potentially what Europe is saying. So when I was doing preparing the presentation yesterday, the European Data Protection Board had published an FAQ which set out a number of questions. Can I still rely on Privacy Shield? Answer, no, you can't, it's illegal. Can we rely on standard contract clauses? Well, you might be able to, but it will depend. You'll need to make a decision on those kind of things. And there was a number of other questions as well. The Information Commissioner had updated their, if you go to their GDPR section on their website, they'd updated their guidance to basically say they're assessing what has happened, and they're going to be producing some further guidance. Now, what happened, and I spotted this morning, and I saw that they posted on LinkedIn about it this morning, so I don't know whether it's dated yesterday, but actually it was done overnight or when it occurred. But they basically published an updated statement, and I haven't quoted the whole statement, but these are the pertinent points and the bits underlined particularly. So what the ICO are now saying is that, so this was of yesterday or potentially from this morning, that because the EDBP, the European Data Protection Board, so that's the European collection of EU member states regulators, it no longer includes the Information Commissioner's Office because of Brexit. But they have now published this FAQ, which confirms the invalidation of the Privacy Shield, confirms that it is illegal, and also brings into question the standard contract clauses and the potential implications there, as I've already discussed. So what the ICO is saying in that third paragraph, further work is underway by the European Commission and the EDPB to provide more comprehensive guidance on extra measures you may need to take. In the meantime, you should take stock of the international transfers you make and react promptly as guidance and advice becomes available. So not only do you need to try and work out what it is they're going to be saying, but you need to be ready to act on it as quickly as possible. And that the recommendation is that you must conduct a risk assessment as to whether standard contract clauses provide enough protection within the local legal framework, whether the transfer is to the US or elsewhere. So this is my point, that if you're transferring data to India and processing it in India, you have to look at what that means for the company that in India that's doing your processing for you, and whether the standard contract clauses, assuming that's what you've used to bind EU GDPR to your processing, to see whether it's appropriate. So this kind of suggests that we all need to now understand what national laws mean with regards to data protection and what the governments might do. I mean, off the top of my head, I don't know whether China, India, other states outside the EEA have national laws which completely trump any European contract clauses on our commercial agreement perspective. And we know they do in the US, because that's the reason the Privacy Shield's no longer invalid. And we have to make a decision about whether we think it's appropriate. Just on that second from last paragraph, I've not underlined it. The receiver of the data may be able to assist you with this. So this is as much about talking to them as your processes as it is about you making, trying to establish what the risks might be from using standard contract clauses. But in essence, this means if you're relying solely on Privacy Shield, you can't anymore, and you need to do something about that. if you're relying on standard contract clauses, you need to have a carry out a risk assessment to determine whether you think standard contract clauses are really appropriate with the processor. So that will be all your processors. So if you're using Google, Microsoft, MailChimp, HubSpot, for example, that's 4 processors you're going to have to carry out a risk assessment against, and you'll need to determine whether you think it's appropriate for you to use their services to process the data. And I think actually, I'm not sure if it's in the EU, I'm sorry, in the GDPR, get my acronyms mixed up. I'm not sure if it's in the ICO's statement, but I think I read in the European Data Protection Board's FAQ that actually you should do everything you can to move your data over to EU. Is essentially what I think they're recommending. So we're going to see some changes in this, and you know, how quickly those changes will happen is difficult to say. The ICO aren't particularly good at promoting and telling people that things have changed. You usually have to work it out by spotting a change on the website or following on social media. But it's certainly an area that's subject to change. Now, what does this mean going forward? Well, keep an eye on, as much as you can, any guidance from the ICO and the European Data Protection Board. I run a mailing list which I provide updates to on a monthly basis. That's one way of doing that. If you want to sign up to that, you can go to my website and subscribe to my mailing list. Obviously, customers who subscribe to my services, they get updates as I post them. So that's a more quicker way to get on top of what's going on. Otherwise, it's pay attention to what the ICO and the European Data Protection Board have to say. You need to look at where your data is being processed and identify where your processors are in the world. In theory, you should already know that, because GDPR requires you to have documented your processing activity, which should include, this is the data, this is who it relates to, this is why it's lawful to process, and this is where it is being processed in the world, and that there are appropriate safeguards in place. So hopefully that's not too an onerous task, but you need to identify where your data is processed in the world and which processors are impacted, and work out which ones rely on privacy shields on its own, and which ones rely on the standard contract clauses. There is unlikely to be any other solution, because the only other solution is there's an adequacy decision in place. And so you just need to compare, you know, if your data is sitting on a server in Israel, New Zealand, Switzerland, Argentina, and those other places that well, I had listed on the previous slide, then you don't need to worry about this at all. But if they're sitting on servers in China, India, in the US, or you're getting those organizations in those countries, just to name those 3, but obviously a much wider area you need to cover, then they will be relying on Privacy Shield if they're in the US, or the standard contract clauses. And some US providers tend to rely on both. So if you're relying on Privacy Shield solely, then that's going to not be legal anymore. If it's a standard contract clauses, then you need to identify which ones apply standard contract clauses, which is why you need to identify location of your data. Have a look to see what your, I've got a slide coming up for some quotes from some common provider website, US provider websites, to see what they are saying, and also to highlight the conundrum that we're all going to face. But make contact with your suppliers and your processors to sort of understand what they're going to be doing about it. If you can choose where in the world your data is hosted, choose the EU or UK. So if you are using a provider that's outside the EEA to process your data, and they offer you the ability to store your data and process it within the EEA, then I suggest you press the button or flick the option or whatever it is that they allow you to do to say, I'd like my data processed within Europe, please. Because then you don't need to worry about the standard contract clauses or any other agreement, because the data will be managed and processed from within Europe. But not all providers have that functionality. Yeah, so see if those processors are offering a solution to allow you to store data locally. You're going to have to take a plunge and decide what you're going to do from a risk basis if you're relying solely on Privacy Shield. Where you're relying on standard contract clauses, you're going to have to carry out a risk assessment on the likelihood of a national law trumping the standard contract clauses. And as the ICO statement says, that's wider than just the US. And if not, you need to decide what the solution is you're going to do. So if you're completely risk adverse and don't want to take any chances, you're going to be looking for EU data processing solutions, so that you don't need to worry about standard contract clauses. Otherwise, you're going to have to make a risk assessment, and I suggest, as number 10 is there on that list, you document your findings and your decisions, because that's the proof that you've actually paid attention to this challenge and that you've done what you believe is right in terms of going forward and why you believe it to be right. And that's part of the accountability principle that's required within the GDPR to prove your compliance. And number 9 there, just to throw in a slight tangent, there are some implications here about what could happen at the end of our Brexit transition, which ends at the end of this year. So from the 1st of January 2021, there will be no transition period, and the UK will be considered a third country, which means we're outside the EEA, and there's some challenges that we're still waiting to find out around what that might mean for EU to UK data processing arrangements, because all this adequacy and the safeguarding that I've talked about, which is what this is all about, will apply for EU data transfers to the UK. But the reason why I brought it in here is that there has always been this intention that the UK were going to rely on the EU-US Privacy Shield as a UK to US data transfer mechanism. They're obviously going to then rely on the standard contract clauses, but who knows, from next year, the UK can do what it likes with regards to data protection law. We will have UK GDPR, which will be, for all intents and purposes, the same as EU GDPR, but this may be an area where the ICO makes sets out a particular position on what it feels about some of these challenges with this particular problem. Now, I said I'd looked at a few of the processes and see what they're saying, and it's not really helpful. So MailChimp, Google, Microsoft, and HubSpot are the 4 I picked on. And they all pretty much say, don't worry, you can rely on the standard contract clauses. They have not been impacted by the court judgment. So they've completely missed the point of this point about the fact that the reason Privacy Shield has been invalidated is because of this national US law trumping it, and it will also potentially trump standard contract clauses. Now, there is an added confusion here, or an added challenge, in that it may not be all US data processors who are likely to be having to hand personal data over to the US government or the Secret Service or whatever, and therefore that's where you're making your risk assessment in conjunction with your supplier, your processor. But I do know for a fact that Google's on the list of companies that are a target of the PRISM program. So is Microsoft. So when Google and Microsoft say that you don't need to worry, we've got, well, as I said earlier, Google refers to them as the model contract clauses, but essentially the standard contract clauses, they're not strictly getting the point that this may not be the case if they've still got to hand over the data regardless. So unless they have functionality that enables you to basically silo European data on European servers where it's not governed by US law, then it's difficult to see how you can carry on using Google or indeed any of these suppliers, because they're all relying on the standard contract clauses, which may not be appropriate. So you have to carry out your checks and balances against these and any of your other data processors. So I thought, I know, I'll have a chat with the ICO and see what they've got to say about it, particularly given that they've just published their statement. And I pointed out that I used Google as an example, and I pointed out that Google were relying on the standard contract clauses, and yet they're answerable to the US government, surely, and that doesn't apply. And in true ICO style, I didn't get a straight answer and was told basically you have to make your own mind up. I didn't say it quite like that, but that's essentially essentially what they said. So what they're saying is that you have to carry out the checks and balances and make a risk assessment as to whether you want to carry on processing your data with those providers. And if you do, obviously, if the ICO turn around and say, we deem Google, Microsoft, HubSpot, and MailChimp as examples as being invalid as terms of standard contract clauses, you need to look elsewhere for your processing because you won't be able to use them. Now, I can't believe that those organisations are not going to implement something that fixes this problem, probably from a technological point of view, but you might have to dig deep to find out what those answers are. You might need to talk to your IT provider or the person that supports you with any of these platforms, or even talk to the platforms themselves to try and get a gist of what's going on there. Or speak to somebody who can help you interpret what all of this actually means in reality. So that was really all I was going to say about that. That's rather a lot to cover. I managed to do it in about 35 minutes. If you need any assistance, then this is exactly why I run the services that I do. As I say, I provide a range of helpline services. At the top end is what's shown on here is a GDPR DPO, but I have a GDPR Unlimited service, which gives you unlimited email and phone support, as well as hands-on help. So that's me doing the hard work for you. I also have online resources, and it's those kind of online resources that I use to publish updates. So it's a great way of getting quick updates as to what's going on. And also, if it's possible for me to do it, publish any advice and guidance around who you can and can't trust and what you should or shouldn't be doing. So get in touch if you want to learn a bit more about that, or more than happy to have a obligation-free conversation to work out whether there's something I can help you with. But just to also tell you about some forthcoming webinars. On Thursday, I already spoke about Brexit. Brexit has some implications for GDPR, and so there's a free webinar on Thursday looking at that. I run a data protection practitioners group called the Article 13 Club, and we meet up every month on the first Tuesday of the month. So on the 4th of August, which is next Tuesday, is free to join. We'll be having a discussion. It's not a presentation-led debate, but it's a discussion amongst practitioners about some of the challenges around Schrems, and it's possible, Schrems II, and it's possible that we might have more of a discussion around what we now know a week on from today. And then next week, I'm also looking at the GDPR implications of the new normal. Not only is GDPR exciting, you can learn about Brexit, but you can also learn about the coronavirus implications as well. It's a look at the way that our businesses are changing, and that means your GDPR obligations may be changing as well. So that's another free webinar. And then from next next Friday, the 7th, I'm restarting my 10-week GDPR workout, which is a training program looking at the detail of GDPR. And if anybody's on the call who attended the last run of that and attended the non-EEA data transfer processing session, I'm going to obviously have to update those slides to reflect what's changed since I ran that a couple of weeks ago. That was all I was going to cover. I've got a question just come in. In a moment, I'll stop the recording and stop the screen share, and then if anybody wants to ask questions face-to-face or Zoom to Zoom, then we can do so. But John's asking, some of the processes we use will almost certainly use sub-processors based in the US who themselves may rely on Privacy Shield. Who is responsible for chasing down compliance between our processors and their sub-processors? So GDPR Article 28 requires you to be sure that your processors are GDPR compliant and that you have a data processing agreement or a contract in place with them. And that should include terms about the use of sub-processors, and they have to convey the same obligations you're putting upon them upon any sub-processors. So in theory, you'll need to have a conversation with these these processors to make sure that they're not relying on Privacy Shield in light of the EU court case, because that would make those arrangements invalidated, and ultimately it will come back to you as a controller if something was to happen because of that. So again, that's a very good point, and that is another area that needs to be considered, and I probably ought to have added that to my 10 things to consider. Yeah, you do need to think about who your processors are using as sub-processors, and that could be anything from hosting companies or people using other platforms of their own that help them deliver the service that they deliver to you. So yeah, thanks, John. That's a very good point.